Hi everyone, good evening, good morning, and welcome to the webinar. For those who don't know me, my name is Joel Bider, and I'll be introducing and moderating this discussion in my capacity of Chair of the Israel Committee of the AIPLA. This is the first bit of programming that our committee has held for some time, and before we launch into the official proceedings, I'd like to take a moment to mention that our thoughts and prayers are with the hostages who are now spending their 425th day in captivity. And while all of us on this webinar realize the importance of continuing to be professional, working hard for our clients and keeping up to date with global IP law, I think this sobering reality is very much on all of our minds. Now, just a few words on the structure of the webinar. The topic is, of course, patent disclosure requirements and the consequences of non-compliance. We're going to start with 3 presentations regarding this topic in respective jurisdictions, with Lukas Wlodarczyk of Infin IP presenting on the European perspective, Yair Ziv of Horowitz Co presenting on the Israeli perspective, and Josh Goldberg of Nath Goldberg and Meyer, who will be presenting on the USA perspective. Finally, Ram Vogel of Horowitz Co will present on the global perspective. And in this regard, it's worth noting that Ran actually chaired the committee that dealt with this issue in the recent AIPPI World Congress. So he's very well positioned to provide us with some good insights. And I believe that some of the other presenters also participated in that committee. In terms of questions that arise during the webinar, we'd ask participants to submit them via the Zoom chat, and we will then handle them once all the presentations have concluded. And to help you plan the rest of your day, we will certainly go no later than 7:30 p.m. Israel time, 12:30 Eastern time. And depending on how many questions there are, we may even be finished before then. One other technical point is that this webinar is being recorded. And finally, I would like to thank Tal Band and his team at Horowitz Co for co-hosting this event, and frankly for putting in much of the work into organizing it. This isn't the first time that we've co-hosted a webinar with Tal and his team, and we always know that we're in very good hands. And I'll now hand over to Tal, who will say a few introductory words.
Thank you so much, Joel, for your kind words and for the opportunity to continue and expand our cooperation with AIPLA and its Israel committee. We highly value this cooperation on any given day, much more so during these difficult times which Israel has been experiencing over the past year or so. We have a wonderful team of experts to discuss the issue which you already presented, and that is no doubt an important issue. Clearly, the disclosure requirements have been set to provide the Patent Office, the competitors, and the public at large with the information necessary in order to seriously evaluate and reach a sound conclusion on whether granting or maintaining a patent is warranted based on the facts and, of course, the applicable law. I will not take up time of our speakers in order to add my own comments on this important subject, but I will take just a little bit of time, take this opportunity to briefly shed light on a related issue, perhaps an additional arm, which in my mind is designed to serve an identical or similar purpose. This being the submission of third-party observations during the examination of a patent application, if observations is the right term to use in Israel. Up until 2012, when Amendment number 10 of the Israeli patent law was enacted, third-party observations were not expressly provided for by law in Israel, but were in fact used, albeit not to any significant extent. As part of the legislative process of Amendment number 10, third-party observations were added in Section 18b(3). However, as a result of pressure placed by our friends at Pharma, with a strong tailwind enlisted from the Patent Office, this mechanism in the Israeli law falls far short of what was then the prevailing norm and tendency in both the US and the EU. Again, since my time is short, I will not dwell further on the subject, but suffice it to say that the wording of Section 18 merely allows the examiner to use documents, underlying documents, provided to it by a third party, but does not mention any arguments or comments clarifying what such documents teach. Moreover, the time frame for the submission of documents by a third party in Israel is very limited, only 2 months after the initial submission by the applicant of its list of documents or references to the Patent Office. This truly is in stark contrast to what the US and EU systems offer. No wonder not much use was made of this tool, which in legal circles is sometimes referred to or remarked upon as the poor man's opposition. Now, I understand that the 2025 work plan for the Israeli Ministry of Justice, together with the Israeli Patent Authority, is to initiate a significant project legislating a number of amendments to our current patent law. This is a follow-up to a call for comments from the public, which was initiated back in 2021, but never acted upon. In fact, the issue of third-party observations and its suboptimal use was mentioned in the government's original call for public comments. It therefore now remains to be seen whether it might be improved upon next year so as to render it more effective and meaningful. So with that, and without further ado, I invite Lukas Vlodarczyk, and I hope I pronounced it right, Lukas, from Infin IP to share with us his perspective, the European perspective, on the subject matter of our webinar. Lukas, please.
Thank you. As you will see, the requirement before the EPO are quite low, and before the UPC as well. I will treat Europe as the EPO, the UPC, and the French perspective, since I'm French. I don't mention other countries. I'm not familiar with other national laws. Could you show the slides, please? And you can switch directly to slide number 2, which is our agenda. I have divided my presentation in 3 topics. What you should do inside the application itself when you draft it in the first place. Then what you have to do during prosecution. And last, what about post-grant proceedings and litigation? How could failure to disclose affect you? And as you will see, chances are you won't encounter many problems with that. So let's start with the next slide, dealing with the contents of the application. I quoted Rule 42, an excerpt of it, which states that the specification should indicate the background art, which, as far as is known to the applicant, can be regarded as useful to understand the invention. So you don't have to point to a specific document. You merely have to state that such or such technology is known and build upon it. And it's going to be treated as a kind of admission. If you cite a document, you don't have to position yourself. You don't have to say what's relevant, what's not. You simply quote it the way that suits your needs. And my next point is to say that this is useful even for the applicant, because you often perceive the disclosure requirement as a constraint and a risk. But this particular requirement doesn't seem to be much of a constraint or a risk for the applicant himself. In Europe, at least, when you draft an application, you have the so-called problem solution approach in mind, because that's the way we address inventive steps traditionally. And for that purpose, you seek the closest prior art, or at least a close prior art. There are some discussions around it, and then you try to measure a kind of distance between this art and your invention, and you have to build a story around that. So it's not much of an issue to have to, in most cases, to have to comply with this requirement. But even if you didn't, not much would happen to you. The EPO would merely do its job, and once established that you do not deserve that, but a much smaller invention maybe, they would ask you to update your description and to mention the prior art that you omitted. In French, I mentioned France, but in France we have a very similar approach, except that the INPI would not even ask you to specify the missing documents in the description if you didn't mention them in the first place. So now let's turn to the next aspect, the prosecution aspect. Once again, it's very light. You are expected as an applicant, if you claim a priority from certain countries which have no agreement with the EPO, to provide the result of the search reports for your first filing. If you filed at the USPTO or in Japan or Korea or others, you don't even have to do that. But if you are in another place, I think Israel doesn't have an agreement, but I'm not 100% sure. You would have to submit it. If you don't, nothing happens. Once again, what's going to happen is that when examination starts, and that may take 2 years, because you pay your examination fee 6 months after publication, and then the examination itself starts even later. When the examiner picks your case, and if he notices that you failed to comply, he will give you 2 months to comply. Then, of course, if you don't comply, you'll have a problem. Your application will be deemed withdrawn. But it's an easy requirement. It's easy to just file what you got in the first place. Not a big deal. In theory, the EPO can also ask information about so-called related application without defining related. So it has always puzzled me, because what does it mean? If I file 2 patent applications at the same time in 2 countries, and if they are close enough, are they related? If I file a CIP of a parallel US application, is the CIP related? Maybe, maybe not, we don't know. But the EPO doesn't even rely on this provision. That's often, personally, I never encountered that. So it's there, but it's a very light requirement. In France, the INPI may ask for prior art that was cited by the first filing office. And the rule is the same as before the EPO in that respect. So really not a strong requirement. And we'll now switch to the last point, which is litigation or post-grant. It could be an opposition, for example. In Europe, the only way to have a patent revoked, whether at the office or in court, is one of the grounds that are listed in Article 100 for oppositions, or 138 for court decisions. And lack of disclosure is not mentioned there. Same in France. So you are never going to have your patent revoked for a lack of disclosure, even if you are a pig, even if you did the worst conceivable lies. No problem for your patent. Of course, you may have other issues, but the patent will stand. In general, you don't have any duty to disclose any prior art before the UPC either. But I mentioned Article 42 and 48, which respectively require the proceedings before the UPC to be fair and equitable and to not distort competition. And 48, the next one, which require that the representatives should not misrepresent cases, and well, basically should not lie, should not hide facts that they know and that they have an influence on your case. That's a broad statement. Consequences in case you behave like that, you don't see them. Well, you see them in the sense that the UPC might report you to your national authorities, to national court or other authorities, in case you lied to the UPC, and your national court might decide to to investigate that. But for the penalty, not much of an issue. Next aspect, although you don't have to disclose prior art, you still have to disclose anytime you initiate an action at the UPC, any prior pending proceedings relating to the same patent or same patent family, for example. So you cannot hide this aspect, of course. And if you hide it anyway, the sanctions would be in terms of costs of damage or damages, costs, procedure costs, attorney fees and stuff like that, the court or office would shift parts of the fees to the other party if you behaved in a way that is really outrageous. But you would have to push it a bit far. The general impression in Europe is that the disclosure requirement is not sanctioned very strongly. You are not really at risk. And I had a backup slide, which I will be able to present, I think, because I still have some time to mention that you may have some form of disclosure requirement when you apply for provisional measures, whether before the UPC or same in France before a French court. It used to be that you could apply very freely. For example, for saisie contrefaçon or for an injunction, you would show that you have a patent. The patent is presumed valid. You have to demonstrate that you have some reason to believe that there is an infringement, and off you go. And more since 2004, when with the directive on the European Enforcement Directive, that has been made a bit more difficult, and you really have to do your homework in before going before the judge. You have to explain your case, and if you know of a very relevant document, you'd really better mention it. If you don't, first of all, if it's a preservation of evidence before the UPC or saisie contrefaçon in France, you're likely to lose everything that you collected, all your evidence, which would be a pain. And you could also have to pay damages to the other party. Aside from that, not much issues with disclosures. The disclosure requirements are minimal and the sanctions are not very high. So I'm done for Europe. If you have questions, of course, we may address them, I guess, at the end of the presentation. I'm not sure. And with that, I will switch to the next speaker, my colleague. Well, just a second, please.
Yeah, will be speaking next.
Yes, yeah, exactly. Yair Ziv from Horowitz.
Okay, so thank you, Lucas. Good afternoon or evening, everyone. Today I will address Israel's patent disclosure requirements, focusing on the legal framework and the serious consequences of non-compliance in Israel, which are more serious than Europe, apparently. To illustrate these points, I will examine two pivotal cases, the Netfree case and the Sanofi versus Uniform case. But first, the law. Sections 18 and 18A of the Israeli Patents Law impose stringent disclosure obligations on patent applicants. There are generally two types of information to disclose. Applicants must disclose citations upon which foreign patent offices base the examination of the same or related patent applications. And applicants must also disclose prior art publications known to them and directly relevant to the claim invention. Section 18C, according to Section 18C, if an applicant provides misleading information or knowingly fails to update the office on any significant changes in the list of citations or publication, the court or the patent commissioner can revoke the patent or deny the patent application. They can license the patent or to any interested party. They can shorten the term of the patent, and additionally, the applicant may be fined under the penal code. The purpose of these provisions is to ensure that the disclosure is timely, accurate, and comprehensive, and that any attempt to manipulate the patent process can lead to severe sanctions. So, first case I wanted to discuss is NetFree versus NetSpark, which was decided about a month ago by the Jerusalem District Court. NetFree, a non-profit organization that provides filtered internet access, filed a revocation action against NetSpark, a company holding a patent for a system and method for content filtering. NetFree asserted, among other things, that NetSpark violated its disclosure obligation by failing to disclose to the Israeli patent offices relevant citations used by foreign patent offices and other prior art publications known to NetSpark. NetSpark responded that any issues during the examination process were procedural errors, not indicative of bad faith or intentional omission. The deputy commissioner dismissed NetFree's revocation action, concluding that NetSpark failed to meet its disclosure obligations under Section 18 of the law by not submitting a complete list of the prior art, but this failure was not in bad faith. NetFree appealed this decision. The case before the district court centered around whether NetSpark had adhered to the disclosure requirements under Section 18, and the Jerusalem District Court ruled that although NetSpark had failed to meet the disclosure requirements, this was not done with willful intent to mislead. As a result, the patent was upheld despite disclosure violations. The second and more interesting case I want to discuss is Unifarm's claim against Sanofi. Sanofi owned a patent for clopidogrel bisulfate, Plavix, a blood thinning drug. Sanofi filed a patent application for a new polymorph of clopidogrel, Form 2, which they claim to be superior to the previously known polymorph, Form 1. However, Sanofi failed to disclose critical information about the discovery of Form 2, specifically that Form 2 was obtained through spontaneous conversion of Form 1. This omission was crucial in the case. The Supreme Court finally decided the case in a further hearing by a panel of 5 justices about 1 year ago. The Supreme Court found that Sanofi intentionally misled the Israeli Patent Office by withholding this material information. The patent application relied on a priority document that was known to be incorrect at the time, and critical facts about the nature of Form 2 were omitted. The court held that the patent law does not negate the applicability of the unjust enrichment law in cases where the patent applicant intentionally misled PTO. The majority opinion clarified that in such cases, it is sufficient for the plaintiff to show that the applicant breached its duty of fairness or acted in bad faith without needing to demonstrate a breach of a specific provision of the law. The court ruled that Section 18C of the Patents Law, which addresses disclosure violation, does not automatically give rise to an unjust enrichment claim. It was emphasized that a patent applicant may be liable for unjust enrichment only if the misleading information was intentional. The court also ruled on the issue of causation, whereby a plaintiff must also demonstrate that a misleading act or omissions on the part of the patent applicant led to it being enriched. This issue was addressed together with the question of materiality. It was held that there was no reason to apply a more stringent test regarding the materiality of the misleading information, so that only deception concerning the information which has a bearing on the validity of the application would satisfy this requirement. The nature of the misleading information may serve as an important indication when examining causation between the commission of the patent being misled and the patent applicant being enriched at the expense of its competitors. The more significant the omitted or misleading information, the easier it is to establish causation. Supreme Court ruled that Unifarm is entitled to compensation based on Sanofi's profits gained during the period in which the patent application delayed competition. The case was remanded to the district court to determine the exact amount of compensation, considering factors such as the conduct of the parties and any actual damages incurred by Unifarm. The decision noted that Sanofi was enriched not just on the expense of Unifarm, but also at the expense of other competitors, consumers, and health maintenance organizations. The broad impact means that the district court may need to consider these factors when calculating the compensation. So some of the key lessons and implications I found in these cases are that misleading the Israeli Patent Office can lead to significant financial consequences, including the need to compensate competitors. Applicants must act in good faith and provide the PTO with all the relevant information, both prior art and internal information that could affect patentability. Unjust enrichment claims can arise independently of patent validity proceedings. This opens the doors for compensation for competitors to seek financial remedies for losses caused by the patent applicant's deceptive actions. Courts will consider the intent behind any misleading or omitted information. In conclusion, the Israeli patent law imposes strict and evolving disclosure obligation on patent applicants. The Sanofi case demonstrates that the profound risk of non-compliance, not just in terms of patent validity, but also in exposing applicants to independent financial liabilities. The Sanofi decision in particular reinforces that misleading disclosure can lead to unjust enrichment claims, creating far-reaching possible consequences for patentees. This is quite different from the situation in Europe. Thank you very much. Next, we'll hear about the USA perspective from Josh Goldberg, co-managing partner at Nat Goldberg and Mayer. Josh.
Thank you very much, Yair. That was very interesting for you and Lucas from the Israeli and European perspectives. Let me bring up my presentation. Everybody see that okay? There we are. So, like my colleagues, I'm here to talk about the patent application disclosure requirement, but only here in the United States. So the US is going to be very different than most other places. We have a very, very robust disclosure requirement here. This is not only due to patent law reasons, but also generally because of how our courts handle litigation regardless of the subject matter. So our disclosure requirement extends to everybody involved, not just the inventors, but anyone who is involved with the patent application. Any patent owner, any patent attorneys, technically anybody in the company who might have relevant information is supposed to disclose it, which can make for some very interesting and unusual circumstances, as I'm sure you could all imagine. But all this information does need to be disclosed in the filing and prosecution of a U.S. patent application at the USPTO, and it's an affirmative duty. You actually have to comply with this. What you need to disclose is not necessarily just prior art, but any and all information which is relevant in assessing the patentability of the invention. What does that mean? Well, of course, prior art is the number one thing we all think of. And if you have perhaps a later publication that came out after you filed your application that essentially says the exact opposite of what you're saying in your application. If you say my drug is effective for treating lung cancer, and here's my data to show why, and the inventors have a later publication showing the exact opposite, that the drug is not effective and here's their data, that's going to be relevant to patentability, and it should be cited during prosecution. It seems a little strange, but if the examiner is paying attention and they see that document, they should raise a plausibility type argument. Well, I don't believe you. Your later data shows it does not work. Without the submission of that publication, the examiner probably would not know to make that type of rejection. This is what we talk about relevant information. Of course, prior art. You also have things like offers for sale, or any products or processes that you're using in commerce or were using in commerce before your patent application filing. Even if they fall within a 1-year grace period, let's say you started selling in November and you file your patent application in December, yes, you can swear behind that that sale in November, saying that was within the 1-year grace period, but it still should be part of the record. If it's not part of the record, if it's not cited to the patent office, the examiner might not, probably will not know about it, and will not at least force you to swear behind and say this was done within the 1-year grace period, we practiced the invention, we conceived of the invention beforehand, all the normal things that you would have to put on the record, which would make the patent weaker after it's granted, because these things did not come through during prosecution, making them ripe and available to be argued during litigation. Like I said, it's not just prior art, it's anything that is material to patentability. It's a difficult standard because who knows what is material? I could think somebody is material, and Lucas, for example, could think otherwise, that it's irrelevant to the patent application. This is why in the US, the safest course has always been, when in doubt, cite. If there's any question, is it material? Is it relevant? Would an examiner want to see it? You cite it in an IDS. You comply with your duty of disclosure and you don't think about it again. We also, as other people have talked about, essentially require you to submit any information that's communicated by another patent office, either in a related application or even in an unrelated application, which might be relevant to your current filing. We have some clients who this comes up very frequently, where we receive information from them, documents cited from a Chinese or Japanese patent office, not in a corresponding related application, but because it's relevant, the subject matter is relevant, they ask us to submit it in an information disclosure statement to the USPTO. Happens all the time. Now, the good news is there's no affirmative duty to conduct a search, meaning you have an invention, you draft a patent application, you file it, you never had to search the invention at any point in time if you do not want to. It does not have any impact on your patent application, other than that perhaps you did not find a novelty destroying reference before you filed. All the normal things still apply. You still have to meet the novelty, obviousness, indefiniteness requirements, patentable subject matter. But just because you did not do a search should have no impact by itself on whether or not you get a patent. However, even if you do not do a search, it is very likely the inventors, some other people in the company, the patent attorneys, know of some documents that are relevant. Even without doing the search, there is a duty to submit those documents to the patent office. So, for example, if the inventors had a publication 4 years ago for very closely related compounds to the compounds you are trying to patent now, even if you did not do a search, clearly the inventors know about that document. It's their publication. If they do not send it to their patent attorney, if you as the patent attorney do not submit it to the patent office, that could be a problem. You're not submitting all known information to the patent office. The other good side, of course, is that you don't need to do any analysis with your submission. It's enough to say, here's the information, examiner, you figure it out. Just list the documents and that's it. If it's non-US documents, you need to provide copies of the documents to the US Patent Office. Beyond that, your duty is filled. What are the consequences if you do not comply? And while my colleagues have talked about it from the perspective of other places in the world, the US is going to be different. So, number one, always comply, because submitting evidence is not an admission as to its relevance. Like I said, you do not need to mention why the document is submitted, why it's different from your patent application claims, but you do need to submit it. Now, if you do not submit all relevant information, the ultimate consequence is that it could lead to your patent being held invalid or unenforceable. What does that mean? That means if you get into litigation and it's shown in litigation that you hid references from the patent office, the court very likely will say, well, while your patent might still exist, it cannot be enforced against anybody. It's deemed invalid. It's deemed unenforceable. You do not get to walk away from the situation with your unclean hands and stop others. And if it's really egregious, the other side really shows that you knew of relevant information and deliberately chose not to submit it to the patent office, that invalidity and unenforceability can extend beyond just the patented issue. It can extend to any patent in the family you may have gotten in the US, or even any patent covering the relevant product. Even if it's under a completely separate prosecution, completely separate filing, a court could say, your hands were so dirty, we're not going to let you have any protection for your product. That is a huge negative. I cannot encourage everybody enough. If, when in doubt, submit the evidence to the patent office, let them decide. Now, let's say you didn't realize there was an issue, your patent issues, and then suddenly the inventor says, oh, patent attorney, by the way, I never told you about these two documents I had. Can that issue be corrected? The answer is a typical lawyer answer, is maybe. If you're not in litigation already, if you're preparing to launch a product and doing your due diligence to find out what are my possible negatives, what do I need to defend against, you can possibly file a post-grant or institute a post-grant proceeding at the patent office, be it supplemental examination, inter partes, ex partes review, or something else, to submit that document to the patent office and fix that mistake. Yes, Lucas, I see you raise your hand here. No? Okay. Let me...
It's an error if I raised it, but...
Okay.
I see it raised, but it's a mistake, sorry.
No problem. So, while there's no guarantee that this will work, again, if it's proven or shown somewhere that this was done with bad intent, it might be too late, but at least you have the option to try. Of course, it's also possible to wait too late. If you're already in litigation, if there's already a competing product out there, and now you realize, oh, we did not submit relevant documents, relevant evidence to the patent office, let's try to fix it. You're in a situation where somebody else has relied on your miscitation. They've relied on the fact that your patent says what it says, it's valid as granted, despite whatever other relevant evidence might be out there that you knew about. Even if you cite it in this post-grant proceeding after or before litigation starts, if your challenger can show that they relied to their detriment before you made that filing, you have a big problem. My strong recommendation, in the US at least, is not to wait, not to rely on this as a cure-all supplemental examination. If it is something you found out, file the supplemental examination as quickly as possible, because you never know for sure what your competition is up to. And sometimes the facts are just against you. This is why it's very important, not just from the patent attorney side, but from whoever is in control at the client, at the company, ask the inventors. Do you know of any relevant prior art? Have you had any previous publications? What else have you put in the public domain? What else are you aware of in the public domain? It's a very strict requirement in the US. If this information comes out later, quite frankly, you are likely sunk. And with that, I believe that is my time. I believe I'm now turning it over to Ran to talk about the worldwide perspective. So Ran, take it away.
Thank you. Thank you very much, Josh. I will just share my screen. Okay, I hope you can see it. In the time I have left, I would like to share with you the work of AIPPI, I think the largest, oldest, and most influential organization in the field of intellectual property. We call it the UN of IP rights. In promoting a resolution to harmonize the issue of disclosure requirements and the consequences of non-compliance. I had the pleasure of leading the study committee that was tasked with preparing and handling the discussion regarding this resolution. And I think this journey has been truly fascinating. It began with the idea of creating a mandatory requirement for applicants to disclose prior art to the patent offices during the prosecution proceeding. However, as we dive deeper and listen to diverse opinions from the different countries, the direction shifted. And in the end, the resolution reached by AIPPI was quite different from where we started. Let's see if I can change to the next. Okay, sorry. I would like to start by explaining the role of AIPPI resolutions. These resolutions play a key part in harmonizing intellectual property laws worldwide. They promote consistency across jurisdiction, guide national legislation, and provide recommendation for shaping or reforming local IP laws. AIPPI resolution also act as reference for governments and international organizations, helping to draft effective IP policies. And by addressing conflicts in international IP laws, this resolution paved the way for harmonized approaches. AIPPI resolutions are developed by its member countries. I think now we have more than 110 countries, member countries in AIPPI. The process begins with research and analysis, where a group from all the countries submit detailed report, and refer to the national law and suggestion for harmonization. The study committee, which include representatives from each country, conduct debates on the issue and prepares few draft resolutions according to those reports. And the final draft is then shared with the plenary session where members discuss and share their opinion and vote. And finally, the resolution is approved through a vote by representative from all the members' countries. I will not go into the detailed analysis of the report received from the various countries. It's interesting. It's on the AIPPI site if you want to see it. But I can point out a clear trend that emerged from this report. There was a significant support for having some level of disclosure requirement, particularly regarding prior art that was already identified by patent offices in relation to corresponding patent application. In addition, many groups lean toward imposing a sanction in cases where the patent applicant failed to meet the disclosure requirement and did not correct the issue when requested by the patent office. And in such cases, the suggested sanction was the denial or withdrawal of the patent application or even to revoke the patent if granted. I think the first two drafts of the resolution was drafted according to this line. But during the discussion in the various forms of the AIPPI, arguments were made that supported the partial or full disclosure requirement. I think the US delegate led by Josh was one of the countries that leaned to that way. And on the other hand, the argument that completely denied the disclosure requirement. The main argument in favor of the disclosure obligation were, I think, improving patent examination quality was one of the strongest arguments. Requiring applicants to disclose relevant prior art ensure that the examiner have access to critical information, leading to stronger and more reliable patent, and reduce the chances of granting invalid patent. Second, disclosure offers significant benefit to third parties. It's increased transparency, helping other inventor or businesses understand the scope of the patent. A disclosure requirement can promote global harmonization, allowing practices across jurisdiction, minimize differences between national law, and create consistency in patent prosecution. Disclosure contributes to efficiency in prosecution by providing relevant prior art upfront. Applicant can speed up the examination process, saving time for both themselves and the patent offices. This is particularly important for countries with limited resources, patent offices. And finally, maybe the most important factor, there is an element of ethical integrity. Disclosure requirement reinforce the applicant's duty of candor and good faith. So while there are strong arguments in favor of imposing a disclosure requirement, other countries, I think led by Australia and Germany, raise counter argument and consideration during the discussion. First, disclosure requirement increase the burden on applicants, especially smaller businesses or individual inventors. There's the issue of overlapping searches. Patent offices already perform their own prior art searches, or at least most of the patent offices. So requiring applicants to disclose the same information might duplicate efforts and add little value to the examination process. Another challenge is subjective interpretation. Applicant may struggle to determine what prior art is relevant or not, leading to disputes about whether the disclosure requirement was met. In addition, the process can add complexity and bureaucracy, imposing disclosure requirement, introduce new administrative step, which may slow down the examination proceeding and discourage innovation. Translation costs also present a significant barrier. If prior art is in a foreign language, translation it into a language required by the patent office can be expensive and time-consuming. And lastly, there's a matter of shifting responsibility. I think eventually most of the country believed it is the role of the patent office, not the applicant, to conduct a comprehensive search for prior art. Actually, the fees paid by the applicant to the patent office are for that exact purpose. So now let's look at the resolution that was ultimately adopted. I think it's an overwhelming victory to the countries that were against any disclosure requirement. The resolution states that no mandatory disclosure requirement should be imposed. Applicants are not obliged to proactive disclose prior art unless national law require it. There is no obligation to search for prior art. The responsibility of conducting prior art search remained with the patent offices. However, where national law do impose disclosure requirement, it should be limited to prior art already cited by patent offices for corresponding application and without any need for any analysis of this prior art, and only when requested by the patent office. APPI recommends that all patent offices share information with each other on prior art by way of common accessible databases or common portal for such databases. I think there is the Global Dossier or Common Citation Document, the CCD. The resolution also specified that submitting prior art should not be seen as an admission of relevance, similar to the US situation. This protects applicants from legal implementation in connection with their disclosure. Finally, the resolution did address the sanction for intentional non-compliance. So in jurisdiction with disclosure requirement, when it is discovered at any time after the patent was granted that there has been an intentional failure to comply with the disclosure requirement, the judicial body should have the authority to partially revoke the patent on that ground, but only to the extent that the undisclosed prior art is detrimental to the validity of the subject matter of one or more claim of the patent. So to conclude, I would say my position, I believe that in the age where technology and now the AI system enable searches to be conducted with relative ease and allow patent offices to share information with each other through accessible and well-known databases, a full requirement for disclosure may no longer be necessary. Nevertheless, I also believe that if the applicant possesses essential and significant prior art or any other document that can influence the validity of the patent application that was not uncovered by the patent office's searches, it is appropriate, even more than appropriate, for the applicant to disclose this information during the examination proceeding, at least in order to avoid unnecessary risk. So this is the resolution that was accepted by the AIPPI, and thank you very much. And now Joel will handle the Q&A.
Yes. Thank you very much to all the presenters for some very fascinating presentations. Firstly, I want to mention that the AIPLA is I don't know if everyone knows this, but the AIPLA is the US division of the AIPPI. And they actually have a very active harmonization committee dealing with issues such as this. So I think firstly, I'm just going to start with a very direct question for Yair before we move to take the conversation to some more general questions. A very specific question. Had Sanofi not misled the PTO, would they have had a higher, lower identical revenue for their product?
So thank you for the question. Sanofi was the owner of a basic patent, and until its expiration, Sanofi charged a monopolistic price for the drug. The misleading patent application remained pending after the basic patent had expired, and the court determined that generic competition was delayed due to the existence of this application. So over a period of, I think, approximately 15 months or so, Sanofi managed to prevent generic competition through the misleading application. And after generic products were finally launched, the drug's price dropped. So it was held that Sanofi was unjustly enriched as a result of deception. So I think they made more profits. I hope this answers the question.
Thank you. Okay, now I'm going to tie a few questions together, I guess. And I'm going to direct this primarily to Josh, but I'd also be interested in hearing Yair's thoughts on this because Israel has a somewhat similar requirement to the US PTO requirement. So much like Josh said, many of us were taught to err on the side of caution in terms of which references to include in IDSs. And I guess, Ran, I very much agree with how you put it. The opinion that you expressed, that it should only be these ones that are real potential game changers that one ought to have to bring to the examiner's attention. But of course, everyone's afraid of what Josh spoke about earlier, which is, what happens when the patent is litigated. As a result, many of us cast the net very wide, and we file, very, very long IDSs that can include hundreds of references. But then in recent years, it's been the case that in many US office actions, you have US examiners taking issue with the length of the IDSs, and saying that I'm not relating to all of these references. And if there are any particular references that you want to bring to my attention, please do so, if you think they're particularly relevant. So actually, one question is how to deal with that when you get that sort of feedback from an examiner. In addition, as some people may know, the USPTO, they're switching to a new fee system in January, and there are going to be escalating IDS fees for the longer the IDS is, the greater the number of references that are included. So given this is the case, there seems to be some pushback at least from the USPTO. And do you think there ought to be a change in best practice for IP practitioners as a result? So first I'll direct that to Josh, and then Yair, if you have anything to add from the Israeli perspective, please.
Thank you, Joel. Those are great questions. To address the first part first, if an examiner says, I'm not reviewing the references, there are too many, please tell me which ones are most relevant, I would absolutely not take up the examiner's offer. The examiner is out on their own. There is no requirement in the rules or in the law for you to do that. Just by submitting the documents in an IDS, you have met your requirement. The examiner is 100% wrong. If you do identify references as being most relevant, and one of the references you do not identify turns out to be very relevant, you've now basically destroyed possibly your resultant patent by doing so. I would absolutely never do that. I would say in the strictest terms possible, examiner, do your job. You don't get to say this. I have met my requirement. You are obligated to review all the references. End of story. And if I had to, I would file petitions. I would go to the ombudsman. I would go to the examiner supervisor, do whatever I could to say you have a rogue examiner here. They're not following the law. Okay. Normally, if you push back once, the examiner will back off because we have faced this. I haven't had to go scorched earth yet, but I'm prepared to do so because I just think it's wrong. As far as the fees and what that means, obviously I'm a patent attorney. I work on behalf of my clients. I never want them to have to pay any more money to the patent office than they have to or should have to. That said, I certainly understand the USPTO perspective of we're getting buried by these references. And having an additional fee for really large number of references is not the worst way to do it, especially when the additional fee is coming in groups of 50. So you don't hit that first additional fee until you submit more than 50 references. You don't hit that second additional fee until you get to more than 100 references. In promulgating these fees, the USPTO released a statistic saying that 87% of patent applications are unaffected by these increased fees. And I do believe that. I really think that this is mostly an issue for the biopharma industry, which unfortunately for me, I do represent. So I do have to talk to my clients about this. All being equal, I would still submit all the documents you have. I would pay the extra fee and I would move on. It's very nice for the patent office to want to do right by their examiners. I also think that if you follow that rule and maybe don't submit some documents, perhaps you'll do it correctly and you submit all the relevant documents, but perhaps not. It's an awful big risk to take. And also, the amount of time your patent attorney will likely need to spend going through the references to pick the 49 best ones, you're going to pay more than the additional fee anyway. I would just pay the additional fee, submit all the references, and move on.
Thank you. And Yair, anything to add from the Israeli perspective?
So in Israel, the short answer is don't intentionally mislead the PTO and you'll probably be fine. I can give a longer answer, but I think this...
No, short and sweet at this hour is good. Okay, and then a question for Lucas. So I think actually the European requirement is sort of somewhat new to many of us. There certainly is that requirement to add the references in the background that comes up in in examination reports, but I certainly never really thought of it as a particular disclosure requirement. So given that there is this theoretical requirement, what is the best way of complying with the requirement without taking any undue risk of the type that we just discussed in the US and Israel?
Well, in the description, you should be very careful when you summarize, and in fact, I shouldn't use this word. You shouldn't summarize the prior art you rely upon. You should, as much as possible, quote it or almost quote it. You can rephrase it, but do not change the vocabulary. Do not rephrase what the prior art says, because this can be used against you. You don't realize when you summarize it very early, when you file your patent application in the first place. You don't realize how that may be interpreted along the way. And when a new prior art is identified, you didn't know it yourself, but your invention is much more narrow than you initially thought. And sometimes your lousy summary may be very detrimental. So my recommendation, my practice tip would be stick to the text. Don't quote it literally, that would be a bit strange, but rephrase it really minimally. to fit in your description. And that's really the only one you have to think about, because the rest is really formal. You simply have to forward what other patent offices have found, and you just forward it. There is no question about it. Do it. Do not hide anything. Of course, the consequences would not be dire, I guess, but most often. But don't do it. That's no point.
Okay. And then one final question for Josh again, if I may. So you sort of touched upon this, but it's about some specific post-grant questions, which are sort of borderline cases. So one is, if a newly identified piece of prior art was found by another patent office in a related application post-grant, do I need to do anything? And if so, how should I do it? And similarly, what about another borderline case where an inventor comes after the patent is granted with a new piece of prior art that they are aware of but forgot to disclose during the prosecution? It doesn't seem to be invalidating. What's best practice in that case?
Good questions. I think they're two very different answers because they're very different situations. In the first, the relevant prior art was only known after the patent was granted. So I don't think there's any issue there of unclean hands or you hiding anything from the patent office. The question really is, how relevant is that document to the granted patent? And at that point, it is only the granted patent. If you see it as potentially being novelty destroying to your granted patent, it may be worthwhile to file a request for a supplemental examination just to make sure it is considered by the patent office, by the USPTO, before you get into litigation. Is it required? Absolutely not. Is there any to do so? Duty to do so? Absolutely not. But if you realize that it's going to cause you problems later, you might want to get out ahead of it. Beyond that, I wouldn't do anything. As for the second question, there's a risk either way. So risk on one side is you receive the document from the inventor, you decide it's not overly relevant, so you choose to do nothing, and then it comes out in litigation later. And your decision that it's not overly relevant might be something that others disagree with, in which case you can face a battle in litigation. Well, you knew about this, you did not cite it to the patent office. Clearly, the inventor was trying to hide something. Your patent is invalid. That's the argument that would be made. The other side of it is, if you do file for supplemental examination, even if you think it's not overly relevant, number one, the examiner can disagree and suddenly cause you lots of problems for what you thought was a granted patent. And number two, because you've reopened prosecution, essentially, once it's reopened, the examiner could probably make any rejection they want on prior art, whether it's that reference or something else. So you run a real risk either way. I think in the real world, most of the people I've worked with would look to see how relevant it is. If they think it is not relevant, they would not do anything. Wait to see if it becomes important in litigation, if there even is litigation, and essentially just keep an eye on things. If it is relevant, I'd say 50-50. Half the people I work with would try to get out ahead of it, file a request for supplemental examination. The other half would still do nothing, say, I have no affirmative duty, I have a granted patent, let the courts decide. There's no one right answer, but that's generally how the decision tree I think people would go through.
Okay, thank you very much. And then I'm just going to read out one more thing, which is more of a comment than a question, but I'll be interested to see your reaction to this, Josh. The whole pay for more references in IDS is a money grab. No examiner looks at all those references in a long IDS now. Now, he's not going to look at them even when you're paid the extra money. He's going to continue to do what he's always done. Say he's looked at them, and we can all pretend like he actually did. But the new fees for long IDSs have nothing to do with patent examination quality. There you go.
I'm not going to say the comment is wrong. It's very likely this is what will happen. And the patent office is trying, in their foresight, in their view, to make things better for their examiners. I do think it is an honest attempt on the part of the patent office. I compare this with some of their other proposed rules or proposed fees that have not gone through, that are clearly egregious, clearly odious, and clearly are meant to do nothing more than benefit the patent office over inventors and applicants, like the terminal disclaimer double patenting rules that were just withdrawn today, or the proposed additional continuation fees. There's no defense for any of those other than as a money grab. Here, at least, there's a colorable defense to say we're trying to make things better for the examiner. Do I think that's really what's going on here? Probably not. It probably is a money grab, but it's written and it's done in such a way that, yes, it does look at least like an honest effort.
All right. So on that note, we'll conclude. Thank you very much to all the presenters. Tal, did you just want to say?
Yeah, I want to thank you, Joel, for mediating this and for making it happen. Thank the speakers for very lively and interesting presentations and discussion. And of course, thank our participants for taking the time and joining us today. Thank you.
Thank you very much.
Thank you. Thank you all.
Thank you all.
Thank you.